Let me take this opportunity to say thank you for your service so far. Would you please stand, raise your right hands? Do you solemnly swear or affirm that you will well and truly try the issues joined between the Commonwealth and the defendant and render a true verdict according to the evidence? If so, please say I do. Is there anyone not so affirming? Now, I want to instruct you that I will be reading from written instructions in order to make sure that everything that I tell you is standard and uniform and in accordance with the laws of the Commonwealth. And I give you this as a warning, even though I will be reading to you, you must pay close attention to what I have to say. Members of the jury, you are about to perform one of the most serious duties of citizenship. You are going to decide whether a fellow person, the defendant, is guilty of a crime charged by the Commonwealth. The way you as jurors do your job is as important to the administration of justice as the way I do mine as a judge, the way the district attorney does his job as a district attorney, and the way the defense attorney does his job as a defense attorney. Pay close attention to everything that is said and done in this courtroom so that you can perform your duties well. The charges that are brought against the defendant are in a formal document called an information. The charge is an accusation, not proof that the defendant is guilty. A fundamental principle of our law is that you must presume the defendant innocent. This means that you are not to accept the mere fact that the defendant is charged with a crime means that he is guilty of it. He begins this case with a clean slate. He has no obligation to prove his innocence. It is the Commonwealth that bears the burden of convincing you that the defendant, who is presumed innocent as the trial begins and progresses, is guilty of the crimes charged. To succeed in its effort, the Commonwealth must convince you that, based upon a fair consideration of all the evidence that will be offered, each and every element of the offense charged has been proved beyond a reasonable doubt. To find the defendant guilty beyond a reasonable doubt, you must be convinced of his guilt to the same degree you would be convinced about a matter of importance in your own life in which you would act with confidence and without hesitation or doubt. I will describe in a general way what will take place. First, the district attorney will make an opening statement in which he outlines the Commonwealth's case against the defendant. The defendant's attorney will make a statement outlining the defense case, either immediately following the district attorney's opening or later in the trial. Second, the district attorney will present evidence. He may call witnesses to testify. He may offer exhibits such as documents or physical objects. The defense counsel has the right to cross-examine witnesses called by the district attorney in order to test the truthfulness and accuracy of their testimony. After the district attorney has presented the Commonwealth's case, the defense counsel may present evidence for the defendant. The defendant has no obligation to offer evidence or to testify himself. The district attorney may, of course, cross-examine any witness called by the defense. Third, after all the evidence has been presented, counsel for both sides will have an opportunity to make their closing arguments to you. I will then give you my final charge, which will include instructions on the rules of law that apply to the case and whatever additional guidance I think you need for your deliberations. You will then retire to the jury room to deliberate and to decide what your verdict will be. It is my responsibility to decide all questions of law. You must follow my rulings and instructions on matters of law, whether or not you agree with them. I am likely to give other instructions during the course of the trial in addition to these preliminary instructions and my final charge. You should consider all of my instructions as a connected series. Taken together, they constitute the law that you must follow. I am not, however, the judge of the facts. It is not for me to decide what are the true facts about the charge against the defendant. You, the jurors, are the sole judges of the facts. It will be your responsibility, and yours alone, at the end of the trial, when you deliberate, to evaluate the evidence and from the evidence find what the facts are. You will apply the rules of law that I give you to the facts as you find them to decide whether the defendant has been proven guilty beyond a reasonable doubt. Each one of us has biases about certain perceptions or stereotypes of other people. We may be aware of some of our own biases, though we may not share them with others. We may not be fully aware of some of our biases. Our biases often affect how we act, favorably or unfavorably towards someone. Bias can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make very important decisions in this case. You must not let bias, prejudice, or public opinion influence your decision. You must not be biased in favor of or against any party or witnesses because of his or her disability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socio-economic status. Your verdict must be based solely on the evidence presented. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by bias for or against any party or any witness. While you are deciding the facts of this case, you will have to judge the credibility and weight of the testimony and other evidence. By credibility, I mean the truthfulness and accuracy of the evidence. When you judge the credibility and weight of a witness's testimony, you are deciding whether you believe all, part, or none of the witness's testimony and how important that testimony is. Use your understanding of human nature and your common sense. Observe each witness as he or she testifies. Be alert for anything in the witness's own testimony or behavior or for anything in other evidence that might help you judge the truthfulness, accuracy, and weight of his or her testimony. Under our law, you will not be given any written transcript of testimony to use during your deliberation. You must rely on your memories to recall the evidence and legal instructions. Therefore, listen carefully to everything that takes place. We have a court reporter who is taking a record of the proceedings. If you have trouble hearing questions or answers while a witness is testifying, raise your hand. If you missed anything significant, the recorder can read back whatever you missed.